Washington State Michigan sound session. All those having business before the court draw near.
You may be seated.
Good morning, Judge. Good afternoon.
Good afternoon. Hannah on a Friday. We just don't know what we'll get.
So lucky.
What?
You're so lucky, Aaron.
Yeah, I am. I always consider myself blessed. And Mr. Dukas, how are you? Good afternoon. And you did get a copy of the order that I signed? I did. Okay.
This is Brecken's fault. I just got an emergency alert.
Court does call the case of the people of the state of Michigan versus Larry Lee.
Good afternoon, Your Honor. Retail Assistant Prosecutor on behalf of the people.
State your name, please, sir. Mr. Lee, you are here for your preliminary examination. Sir, you have elected to represent yourself. Is that still your wish, sir?
Your Honor, I have not received any of the requested discovery material. I've sent out written requests for the prosecution and my previous attorney and haven't received anything. So at this point, I'll be needing an attorney to assist, to represent me.
Your Honor, if Mr. Lee can maybe put on the record where he sent that request. I have not been informed of the discovery request from him. My understanding was that Mr. Burgess had a discovery materials.
I sent it to 200 North Main Street.
But well, there are two issues really involved. You sent out that you wanted a copy of your discovery. Are you indicating that Mr. Burgess did not provide or share with you your discovery?
Correct. I sent out one to the prosecutor and one to Mr. Burgess.
No, I'm asking a different question. At the point in time that Mr. Burgess is representing you, are you saying that he did not share the discovery information with you?
The only thing that I received was a police report, a 2-page report. That's it. So I didn't receive the file that he was referring to last court hearing. I didn't receive that. No.
All right, let's just cut through the games and charade here. Do you wish to be represented by an attorney?
At this point, yes, I don't have any material.
Well, it's not an issue of the material. Do you wish to have an attorney represent you?
Yes.
Okay, under the court rule, he is entitled and can ask for that at any point in time. This is probably going to cause great inconvenience for people.
He finally figured it out.
And now here's the weird part of the system. While Mr. Drukas, I've appointed as standby counsel, I need you to get to the MAC office and see what we can get. All right, take it back. We'll get that resolved, figure out what the MAC office wants to do.
When we come back, I just want to make sure I don't forget other case that you want to address that happened after the last court hearing. So we can do that when we come back.
Something that happened after the last.
Yes, Your Honor.
You were just full of surprise. It's fine. I'll deal with it then. Court's going to stand in recess.
All right.
Really?
I couldn't help myself.
Good to see you.
I also have, that was Brecken's fault, but I also have this on hand.
We'll start with advising people of their rights as a tenant in a landlord-tenant
This is
proceeding.
from Zach.
I'm Judge Middleton. This is the courtroom I get to use. I get to have my name on the plaque. And you're here either at the courthouse or
I'm the judge in this here room.
by telephone or by Zoom. Ms. Harris, I'm not afraid to have you in the courtroom. We've got you in that conference room in case there's a need for you to discuss things with legal aid. And we could set up a breakout room where you could talk with them. But all of you are here on a landlord-tenant matter. The first matter we're going to take up is V squared versus Hively and others. Natasha Hively is here. Carissa Finneman Rarick is here on behalf of V squared, and John Bush is representing them.
Kim just took this message. It's a 9:10. Stephen Adams.
All right, Gary Coy was in for a brief second. Am I supposed to call this guy?
Yes.
Okay,
Actually, Roberta Coy is here too, but I put her in too soon,
put her in where?
the conference room, because Rachel Harris, the 9:10 one.
Why don't you? All right, why don't you bring her in here?
Bring her in here?
Mhm.
Okay, will do.
All right, this is filed as a demand for non-payment of rent. This is a new complex just on the edge of Centerville with 54 units in it. Is that correct?
Yes.
And the rents are about $1,000 a month. And I had expected once the place was up, we'd start to see cases from there. We haven't seen very many, but we're starting to see them. Also here, on the complaint, are Sarah Strout and Joseph Whitaker. Ms. Hively has a personal protection order against Joseph Whitaker.
SovCit was at
which
the
is
beginning,
File number 25234PP,
the
which
intimidator,
prohibits Mr. Whitaker from coming to that address.
but it was short.
And that order was issued by Judge Pattison in March. Well, the posture of the case is in right now, it's a demand for non-payment of rent, that the rent is delinquent. Mr. Bush has provided me with a accounting sheet, which I greatly appreciate. At this point through August, Mr. Bush, you contend the rent arrearage is $3,000.
Yes, sir.
Apparently, I have to thank Melly Jelly for the SovCit clip, and I'm trying to figure out if the Sov is coming back.
With a $213 in cost, 67 cents, and $120 in late fees through August. The amount is $3,333.67. Is that correct?
Yes, Your Honor.
All right. Ms. Hively, you sent me a letter and set
Did.
forth the background here, and I'm aware of the circumstances. I also got some other correspondence and some emails. But this is simply a matter of whether the rent is paid or not. At this point, they contend that your rent through August is $3,000, which means it hasn't been paid in June, July, or August. What's your position?
I sent you a copy of the payment history.
Yes.
I do believe it was paid in June. I'm not 100% sure, but
Well, you sent me this thing. It shows March, April, May. That doesn't show June.
okay. Well, here's the thing, Your Honor. I'm not opposed to non-payment. That's not where I had asked for a written early termination due to domestic violence because he would not leave the property and nobody was making him leave the property.
Well, it's not, the landlord can make him leave the property with a legal action, but they can't just force him out. But theoretically, it was in violation of the PPO and the sheriff should have been. So are you no longer there?
I left there in March, and then I asked in March, I sent you a screenshot of mine and her conversations where I asked for an early termination due to the events that were taking place and the abuse that was taking place. Because I could no longer stay there and nobody was forcing him out.
All right. Let's talk about this. So are you willing to just relinquish the unit? Do you have all your stuff out?
No, I ended up, I went there one day with the police officers. They still wouldn't make him leave even with the PPO order. I don't know why. They didn't give me an explanation. I was able to grab one carload of things and we fled to another state because he was threatening to kill me. But this eviction is going to cause problems for my future because nobody's going to want to rent to me because of his abuse and his choices and his decision. And I didn't have anybody supporting me to get away from him.
All right. So you're out, you're not living there, but all your stuff is still there?
Yeah, I just
No accountability, none. I made a bad choice with the mate, and nobody was there to bail me out. I mean, that's unfortunate, but that's not, like, it's not like required by law that someone's there to bail you out from your bad decisions.
pretty much washed my hands of the whole situation. I don't want nothing to do with him. He was still there up until I guess the police officers made him leave. Yeah, I just don't want anything to do with that man or my belongings. I can start over. That's fine.
Sir?
Is he there?
Yes, I'm here right now.
All right. Well, you're late to your own party.
No, I've been trying to log in, but it wasn't working. Sir, she has charges.
Well, just a minute. Just a minute. Are you Joseph Whitaker?
I am, sir.
All right. I ask you to take your hat off.
Your Honor, I even have an email from Joseph Whitaker.
Stop. All right, Mr. Whitaker, are you still at this apartment? No, he's frozen. Mr. Whitaker,
Yes,
are you still living there at this address?
I am. Yes.
All right, well, you got to pay the rent. You owe $3,000 in rent, $213 in court costs, $120 in late fees. So the total amount of rent due is $3,333.67.
I applied for the MDHHS, the SER, the SIR application. I'm just waiting to hear back.
All right. One of the problems is the personal protection order that's in effect prohibits you from being at 2 Boulevard, Apartment 1. So you have a personal protection order in effect that says you're not supposed to live there.
It shouldn't be in effect anymore. I had went in and what is
It
it
still
called?
is, Your Honor.
No, it's not. No, it's not.
I called and made sure from the judge myself.
Stop. Mr. Whitaker, the order is in effect. You don't just call up and ask them to drop it. Judge Pattison orders
No,
that you not live there.
I didn't call. I actually went there. I
you have
even
a hearing in front of-
tried to serve her. I tried to serve her papers
All
to
right.
go to court for that, and she never showed up.
All right, the PPO is in effect. You're not supposed to be living there, but she's not there, so I guess maybe it's not as important. I can't imagine they're gonna give you money to pay your rent on a place that you're not supposed to be living at, but the law requires I adjourn this for 7 days.
Okay.
And then I'm gonna tell you that you owe $3,333.67 by 10 days from next Friday, which would be the 25th of August. I'm sorry?
That was on her end. I don't know.
Yeah, Miss Hively, what did you want to say?
No, that wasn't me. I'm sorry.
Okay.
I was just letting
Anyway,
you- I was
Miss
trying to
Hively,
make sure-
you're out of there, so it's less crucial for you because you don't really care. If he doesn't pay the rent, he has to move out, and that's up to him. If
Well, I
we
had
get
to leave. I didn't have a choice. He wouldn't leave. I even have an email from him saying, please don't kick me out. That's why he ended up putting his hands on me. 'cause
No,
wouldn't
I
let him
never
come
put
back.
her, I never.
All right.
Shut up,
Stop,
Tasha.
stop. This isn't a PPO hearing. It's a non-payment of rent hearing.
Yeah.
And we're quite busy next Friday. 9:20, 10:30, 11.
Embarrassing.
John, you're gonna have several of these. How about if we continue this to 8:30 on Friday, August 15th? Does that work for you? Oh, that's the first, that's first pre-day.
Are you talking the 18th, Your Honor?
Yes, the 15th, Friday, the 15th.
Okay, I have one already with you. I have one pretrial right now scheduled early that morning.
What-
I think I
what
have
time?
something,
Which case do you have with me?
I don't know. I think it's set about 10:30.
Memory Lane at 10:30.
Mhm.
Let's set this for 10:40
That should work.
on August 15th. All right, Ms. Hively,
Yes, sir.
you're also welcome to be here. I'm going to tell him that the rent has to be paid or he's subject to being evicted. It's unlikely he's going to get emergency financial assistance for a house he's not supposed to be in. But we'll see where that goes. If the rent is paid, then you get to stay. If the rent is not paid, then he's going to have to move out by August 25th or be subject to being evicted. But we will revisit this entire matter next Friday at 10:40.
Your Honor, can we make, where is Sarah Stout, the other defendant?
Yeah, where is Sarah Stout?
I'm here.
All right, who is she?
She's named in the complaint.
Yeah, how are you related to this, Ms. Stout?
She
I
was
was on
my
the-
roommate.
All right, so she's with Natasha. And
Your
she
Honor,
was
for
also-
just a minute, can I say something as well?
Yes,
Sarah moved Joseph in. Joseph is never even on the lease. We rented to Tasha and Sarah. I didn't move.
I moved in the same time they did.
No,
all
he
moved
wasn't
together.
welcome there, Your Honor, and I have proof of it if you need it.
Stop lying, dude. You gave me the house key. You gave me the house key. Stop lying.
all right.
Your Honor, like I said, I have proof if you need it.
Oh, yes, and I do too. God.
Well, let's take a look at the lease. Well,
I
anyway,
actually moved in before they did, to be honest with you, a week before they did.
well, you're not on the lease.
Well, I didn't
And
know
you're
that.
not supposed to, you're not on the lease and you're not supposed to be there pursuant to a personal protection order.
I went
They're
to
not
court-
going to give you any financial assistance to live there. You're not on the lease. So
I went to court for that PP order. I don't know why it's saying
you
it's
did
active.
go to court. It hasn't been dismissed.
It should have been.
Well, perhaps, but it has not been. He's not on the lease. So I don't know what the deal is, but somebody's got to pay the rent. And Natasha and Sarah are not going to pay it. So my advice to you, Mr. Whitaker, is you find another place to move to, because I'm going to give you 10 days from next Friday to move. They're not going to give you any emergency financial assistance for a property on which you're not on the lease. So, all right, we'll address this further next Friday. That took
Your
us
Honor,
much.
I have a question. This is
Yes.
Natasha. Is this eviction gonna be on my record?
It will be unless we otherwise resolve it.
So due to no fault of my own and nobody making him leave, it's gonna be on my record.
Hey, take responsibility, Tasha.
I'm going to mute him. Yes. Nobody put you in a relationship.
It's the only reasonable thing he said so far. The first time he utters a rational thought, he gets muted.
With him. I'm not sure what happened and I
No,
don't
no,
know
no, no,
why.
no. I wasn't in a relationship with him. I'm trying to tell you. I have an email from him telling him not to kick him out, and I told him he was never welcome in the first place. Sarah had a relationship with him.
All right.
Her and I had an agreement. He was not
All
supposed
right,
to be
well,
there. He
then
was not welcome
that's
there.
on you guys, but yes, it will go on your record unless it's somehow otherwise resolved. So I'll see you next Friday at 10:40.
Your Honor, do I need to be here too?
Are you Sarah?
Yes, I am Sarah.
Oh, I didn't realize you were, yes, you're welcome to be there too, Sarah. So you were in the relationship with Joseph?
Yes,
All right, this is even more complicated than I thought. I thought she was. Yes, but as far as I can see, you don't want to come back there anyway. So yes,
no.
you should
I
all
left.
come back. All right, thank you. I'll remove you as well. So Sarah was here. She was not properly named. I didn't know who she was. All right, we're off like a herd of turtles. Mr. Whitaker, I'm going to remove you also and send you into the great wide open.
See, I'm going to use Miss Fowler's word. She now is in a throuple. And not only does she choose to be in a throuple, and she's shacked up in the bed with the throuple. Now, if anybody thinks this is okay, I am in the wrong world.
Well, all right. That's all good stuff. I'm not sure if the SovCit that kicked this whole thing off, is he supposed to be coming back? I'm looking at the feed. It's still private. I was so busy. I was trying to put together a thing that was just chaos all the way through. That was just absolute chaos all the way through. All right. Does someone have a link to something that I should, in the meantime? Let me find something.
This bill. So I had contacted her, called her on the phone and tried to have a conversation with her. She had told me that me as a contractor should know that there is water going into her crawl space.
Hey now.
And so at that point, I had just responded that as a contractor, I'm not sure exactly how I would know that there's water going in your crawl space.
I'm just killing
It's
time
been 3 years.
till the intimidator returns.
I also had asked her why she did not contact me. I had no idea any of this was going on. If she had contacted me like we had stated in our contract or talked about that, I would go ahead and I would take one of my subcontractors and we would go ahead and figure out what's going on. I also said to her on the phone that you really need to make sure why there's water going into your crawl space.
Increase the water in the crawl space.
I had we had our stormwater report done, so all the stormwater had been done correctly. I didn't know why there was water going in her crawl space. I didn't have the opportunity to figure out why the water was going in her crawl space. It was 3 years later. And she had stated about her not trusting what we said. She had called about a septic problem, and our policy is that if you have a problem, let us know, and we will then give you the number of the subcontractor after you had moved in, and then they need to come and take care of it. If they do not take care of it, contact me and let me know. And that had not happened either. She had told me about the septic. I gave her the septic number, but then I never knew that she was having problems. So I guess that's why she was saying she didn't think she could get a response from me 3 years later. Anyway, I guess what I'm saying is if I had the opportunity to fix or even go look at what the problem was that we.
That
would
I
have,
gave
but
Ms.
she-
Milligan,
I
I'm
had
assuming
no idea
bacterial
that anything was
vaginosis.
Going on until 3 years later.
Thank you, Ms. Ventura.
Yeah.
Okay. Now, in a claim like this, the plaintiff has a burden of proof here by a preponderance of the evidence, and this claim is not proved by a preponderance of the evidence. There's apparently a contract behind this somewhere. There's no contract submitted in evidence here. The specific
I
terms
did
and
submit a
conditions are-
contract. I'm sorry, there is.
Ms. Ventura, please don't
Okay, I'm
step
sorry.
in. Okay?
Sorry.
So the specific terms and conditions are unknown to the court, but beyond that, if there was any kind of unsatisfactory work, it would still be the plaintiff's burden to show that the work was done below.
I don't know about that.
The industry standard or below the.
There's a serious cock shortage in the world.
To be expected level of quality. I mean, there's nothing here to indicate that the defendant did anything incorrect in their construction of the house. In addition to that, there's no causation shown between anything that the defendants may have done and the presence of the water or the cracking of the porch. All of that needs to be proved. The court just can't assume that it's true or that it was caused by the defendant because you say they are. So they're just, the burden of proof has not been met here. So I'm going to enter judgment in favor of the defense. All right. Yeah. So then you're both on Zoom. So the court clerk will record the court's judgment and send a copy of it to both of you by email.
I can't really poach Zach's videos on top of him sending me a bunch of stuff.
You need to print another one.
I'm pretty shameless, but not quite that shameless.
Thank you. Okay.
Plus, we can't miss out on this hot thermos action.
All right. Any other updates? Okay. All right, so that's Kenneth Bannon versus Desmond Kene. 39036. I see Mr. Bannon, you're here on the Zoom call, and Mr. Kene, you're here in the courtroom, and you can just grab a seat there at the table. Okay. Get the party sworn in. Can I have both of you raise your right hands, please? And do you both swear the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
All right, and Mr. Bannon, you're the plaintiff in this case. You get to go first. Yes, go ahead, sir.
Yes. All right. Well, on I responded to an ad on Craigslist
Great start.
to
Great start.
have some routine maintenance done on my car,
Mhm.
just merely replacing the spark plugs. Because newer vehicles have more pieces above where the spark plugs are, I decided to have somebody else do it rather than myself, which I generally do on my vehicles. I responded to this ad. The guy assured me he had 14 years experience, had his own shop at one time. And 2 hours after having dropped it off, he's texting me and says the engine's making a horrible noise, and he says I'm going to have to start taking the engine apart because making a noise. I asked on page 3 of my evidence, I asked, why would you even consider removing the head? He says, because there is something that dropped down in there, which I'm guessing was the missing bolt. Well, Your Honor, you may know that the tolerance inside of an engine are measured in thousandths of an inch. You can't
probably
drop
doesn't.
bolts down into the pistons and cylinders. Within a day, he'd removed the top of my engine. Within 2 days, he removed the heads to my engine. He found that a piston would, if you look at pages 4 and then 5.
Mr. Bannon, you appear to be referring to some exhibits, but I don't see any exhibits submitted in your case.
There's 31 pages, Your Honor.
Okay, when did you submit those to the court?
On the 31st.
It looks like they.
It shows up in on my court.
Where are they?
It looks like the metadata isn't set up, so I just need to add that in.
Okay. All right, stand by a second.
Was that big? So I think it should-
Just this one page. Try that again. Okay. All right, go ahead then, Mr. Bannon. I've got what I need now.
Okay, well, as I said, if you have the table of contents there, page 1 is the ad I responded to, page 1 and 2. Page 3 is after I dropped my truck off on February 15th, and was told to return in a couple hours because that's all the job would take for routine maintenance of replacing spark plugs, which I provided. I received a text that said the engine's making a horrible noise, never had this issue. I'm going to have to take apart the top of the engine to see what's happened. I asked, why would you do that? Because there is something that dropped down in there, which I'm guessing is the missing bolt, which he had mentioned in a telephone call, which I don't have a record of, but now you see it here. So if you turn to page 4, 1 day later, the top of my engine is off. For the 2 days later, the head, which was on page 4, is removed. And now you're looking at the block. So something dropped down into that center piston, and you see that it's gone. It was demolished. If you look at on page 5, the top piston is showing, the lower piston is showing, the middle one is not, because it was demolished and fell down into the crankcase where the oil goes. At the maximum point of dismantlement, he asked me, did you think this job is free labor, on page 6? And what I'm thinking is that somebody's done something to my truck and that they're trying to make it right. That's what I'm thinking. You know, that's what people do. So you can read that, Your Honor. So on page 7, he's given me a list of parts he needs, because I can't do anything with my truck at this point. He said that in the the mediation thing, that he never drove the truck. Well, that's not true. He did drive the truck. He drove it into his garage. I left it in his parkway. It was running fine. It had been out to Yelm the previous day. It had been down at the California border the week before. This is routine maintenance. So he gave me a list of things to buy on page 7. Page 8, you can see that beginning. Initially, I stopped by his place at February 15th. I started buying parts February 27th. You can see I bought the spark plugs on the 12th. And there are a series of receipts for all the things that he told me to buy, because my truck was hostage at that point. Then he started asking me for more money, telling me that the shop rate's $200 on page 12 per hour. And then also on page 12, you'll see my response to that. But still, I'm in a hostage situation, Your Honor, and the only vehicle I own is in the garage of this man. So I had to be conciliatory, try to come with a good outcome somehow. Not what I expected when I dropped my truck off for routine maintenance. So after 2.5 months of his doing nothing on my truck, it sat there in front of his house in the road from February 15th till the day I had it removed in early May. He kept saying that he didn't have time to work on it, excuse after excuse after excuse. I had my sister call him and pretend to be a customer. And he says, "Oh yeah, come on over. I got plenty of time." But he didn't have time for this. So as you can see on page 13, 14, and 15, this is the condition of my motor when I picked it up 2.5 months after I dropped it off to have my spark plugs changed. You'll see the open cylinders on page 15. They're full of rust. Not only had the engine been totally dismantled at this point, it now needed further dismantlement by somebody to take all this apart and clean it. On May 4th, I believe, it might have been the 5th, I'm not sure.
Court does recall the case of the people versus Larry Lee.
On Marie Tan, Assistant State Attorney on that.
Good afternoon, Edward Drupas on behalf of Larry Lee.
All right. Mr. Lee, I've signed the order appointing Mr. Dukas to represent you in this matter so that you're aware. Okay, all right. So in this matter.
Set for a preliminary examination, I'm asking for a brief adjournment. I understand your timing with the court that Monday morning would be available. If we could set it for that time.
All right.
Opportunity to go over discovery.
Will that work for the people?
Yes, Your Honor. We'll have witnesses present.
All right. So preliminary examination in this matter will be adjourned. Court finding good cause to do so. I will adjourn it to what is it, the 11th?
Yes.
August 11th, 2025, 9 a.m.
Thank you, Your Honor.
For me.
When the court's ready, I have a couple of matters to put on the record.
Yes.
Your Honor, first and foremost, after the last hearing we were here for, the victim was present with a support person. As they were leaving the courthouse, they were addressed by someone who identified themselves as the friend of Larry Lee. I believe that person is now sitting in the gallery here today. I personally warned her, but I would appreciate it if you could repeat that on the record, that the victim is not to be talked to or contacted. I don't have anything indicating that Mr. Lee directed that contact. But I want to make sure everybody's clear so we don't have any further issues regarding contact with the victim of this case.
All right. And which individual are you referring to?
This lady right here.
Emma, you come out this way.
Ooh, this is interesting.
Hi.
Hello, what's your name? Yeah.
Hello, Your Honor.
Oh, boy.
I'm Jeanette Thompson.
Hi,
What
Jeanette.
did you want to tell me?
Okay, so just to begin here, I'm very respectful. I don't know nothing that happened. When the I believe it's the victim was walking out, he was staring at me and I'm with 3 different women. And since he was staring at me, I said, are you so-and-so? I could identify him. So I think he was just irate because of what he going through. I don't know. But to be honest, I don't know that man. When he was talking, he was using verbal language. He walked back towards me and 3 other women and was kind of upset. And I said, I just want to know if you okay. My bad. I could identify him. That was all it was. I just said, I just want to know you okay. I don't.
Okay, so just stop it right now. Yes. So I don't want you to have any contact with the victim in this case whatsoever. It doesn't matter if you are worried about whether or not they're doing okay or anything along those lines. You just not to have any contact. Because ultimately, while the people don't have proof that Mr. Lee's involved with that, it could be attributed to him in regard to the behavior, and I don't think you want that to occur. All right? So I don't want any contact whatsoever. I understood.
Yes, sir.
All right? And if I do find out there is, at minimum, I would have you report.
Well, please, can you tell him not to walk up on me
I'm
again?
not going to tell him that.
Okay, because that was
You are, well, hold on. Here's part of the court proceeding.
right.
You are not.
Correct.
So you need to, if it's necessary, you need to get out of his way. There's court security if that
Got it.
becomes an issue for you.
Okay.
Or you can just make the election that you do not need to appear. If you want to see the proceeding that is happening with Mr. Lee, then certainly you may view that on YouTube. So there isn't a reason for you to be here.
I'll talk with Mike.
There is a reason for him to be here.
Got it. Okay.
Understood?
Yes, sir.
All right, thank you. You can have a seat.
Thank you, Honor. One other thing regarding the discovery request, that Mr. Lee said he had sent one to our office. I just received the email. It was labeled a FOIA request, so it went to our appeals and FOIA department. It appears it's a mix of, and I'll make sure to share this with Mr. Drukas, but essentially it appears he is attempting to FOIA communication that I may have had with the court, that I may have had with Mr. Burgess. There's also a grievance / investigation request looking to, it appears, grieve me, potentially more people. I haven't read through the whole thing. Somewhere in there, there's mention that he wants anything related to this case, but the overall idea and heading is FOIAing all communications that have happened in this case, as well as attempting to grieve myself and potentially other people. So I know at this point, Mr. Drukas is appointed, he'll get all the discovery. We've been in communication. I've asked our office to expedite the video discovery to him. I handed him a report that's unredacted, but it is the full police report. So we'll take care of that. But perhaps there should be a conversation Mr. Drukas wants to have with Mr. Lee about the rest of it and anything that may or may not be brought up as part of this case, and that the grievance process is a separate process, which he is entitled to.
Right. That's what he wishes to do. All right. Anything from over?
Nothing further.
All right. Very good. Thank you, folks.
Thank you.
Everybody have a great weekend.
Thank you.
Bond will continue at this time. We'll see you Monday morning. Thank you for this week. It's been enjoyable and always, Anna, great job. We are done finally with this week. Next week will be better. 14A stands adjourned.
Well, there you have it. There you have it. We got all of it, people. We got all of it. We're never going to find out what happened to the guy with the bad repair. It's just not going to happen. But we did get the SovCit complete. I was disappointed. I anticipated this. I was disappointed when they came back because, of course, we've got an attorney saying rational things, ruining all the fun for everybody involved. But then no. The prosecutor says, hey, I'm not specifically saying he's at fault, but can you knock it off? The old witness intimidator over there may or may not be up to his usual tricks, but can you have his people leave everyone else alone? So that kind of got fun. I don't even want to go into speculation about that particular person. I have thoughts that probably shouldn't be shared. Well, just because I don't know. I just don't know what I'm saying, but I have questions. Oh, good Lord. Well, there you have it. I was not planning on that, but it's interesting. So I did a stream yesterday. We had 3 SovCits on the call. Only one showed up. Only Magoo showed up, although it was worth it for Magoo alone. Who is it? Bonnet Boy didn't show up and had a warrant issued, so he'll get drug in at some point. I'll be curious to see if he has a bonnet on from custody, because that's where he's headed. That next appearance is going to be from custody. But this guy was on the call and then taken off the call for whatever reason. I don't know, but he it reared its ugly head today, so I had to follow up. Sorry, the Miami thing and the Thurston thing, that was just me killing time, waiting for them to come back. Nothing too exciting, but we got there. Thank y'all for coming out. I appreciate it. I'll see you soon.